Now that Texas is one of the nation's most restrictive abortion laws, legal challenges are now expected that could be heading to the highest court in the land.
As supporters see victory for the unborn, opponents say banning abortions after 6 weeks is before most women even know they're pregnant.
Jesse DeGollado spoke to the former dean of the St. Mary's School of Law about what will probably be a legal challenge ahead.
Now, we're about to make it law.
With the stroke of a pen, Governor Greg Abbott radically changed the state's longstanding abortion statute. The former dean of the St. Mary's Law School says Texas had set viability outside the womb at 20 to 22 weeks. But now,
Texas statute backs it all the way up to the presence of a heartbeat, which may occur as early as about 6 weeks, and the woman may not even be aware of it.
Legal challenges that he says could wind up before the Supreme Court next year when it hears a Mississippi case that sets viability at 15 weeks. Even so, he says he doubts a conservative high court would actually overturn the landmark Roe v. Wade that legalized abortion.
The Supreme Court rarely directly overturns precedent. It happens occasionally.
But if it is, he says the high court wouldn't declare abortion illegal. Instead, that would be up to individual states.
Allowing the voters to decide whether abortion would be legal or not legal in the state, kind of like the death penalty.
Based on his more than 40 years of experience, Pyatt says he believes Roe v. Wade will remain the law of the land.
But the states will be given more rights in terms of restriction.
Jesse DeGollado, KSAT 12 News.